This is case number 21-167724. This is Auto Club Group versus Monique Moses and Victoria Williams. The matter is before the court, set on for review. I have received earlier this year the answer of Victoria Williams. Your appearance for the record for Auto Club, please. Auto Club, please.
I don't think we will check it.
Do I have Monique Moses or Victoria Williams on the Zoom? All right, we'll pass on that matter for we're now calls 22-179-759. This is TJ Medical Supplies LLC versus City of Detroit. The matter is set for a pretrial conference on today's date. The court previously established a scheduling order that allowed discovery through today's date and set this matter on for pretrial. Your appearance for TJ Medical Supplies, please.
Good morning, Your Honor. Mohammed Hamoud appearing on behalf of plaintiff.
And your P number, if you will, for the record, Mr. Hamoud.
Sure, P86140.
Thank you, counsel. And good morning to you, sir. I'm calling now for counsel for City of Detroit. You may at this time your appearance. City of Detroit. Right, counsel, you spoke to anybody from the City of Detroit this morning regarding this matter?
I have not, and I don't see him on the Zoom call.
All right, so how has discovery gone with this matter?
We haven't done no discovery on this case, Your Honor. I know there's an underlying case that's pending. I know Mr. Callahan was looking into that. If you would like to adjourn it to a further date, I have no issue with that, considering opposing counsel is not here.
All right, so there's been, I guess there's been some talk about coordinating activities between that circuit court case and this case that about the side.
Correct, Your Honor.
All right, so what I'll do is I'll continue the scheduling order forward, and I'll set this matter for a pretrial review. We're going to take a look at it on the 9th of January, January 9, 9:30 a.m., January 9, 9:30 a.m., 2023.
Sounds good, Your Honor.
All right, good day to you, counsel.
You as well. Take care.
Court does fine calls for continuing.
What was that date, Judge?
That date is the 9th of January, 2023 at 9:30.
Okay, thanks.
Thank you. The court now calls case number 22-183381. This is LBN funding versus Iola Hall. The matter is before the court. Looks like the court set this up for a scheduling conference. Well, actually, the court previously issued an order for discovery, scheduling this matter and setting it over for today's date for a pretrial conference. Your appearance for the plaintiff in this matter, LBN funding. Counsel for LBN funding.
I think that's Mr. Rusin. I don't know.
Yeah, I can note that in the file. Do I have Iola Hall? All right, I'll recall that matter momentarily. The court now looks to case number 22-178881. This is Auto Club Group versus LaFlora. It's right there, Teresa LaFlora. The matter is before the court, set on for a pretrial conference. The court previously scheduled and allowed for discovery of this matter. Your appearance for the plaintiff Auto Club in this matter.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff. And this is also the date for plaintiff's motion for summary disposition.
Madam Counsel, and good morning to you. I'm looking now for Teresa LaFlora. If you're on the Zoom, please say something at this time.
Hi, this is Tyresha LaFlora.
Thank you, Ms. LaFlora, and good morning to you, ma'am. I've set this on for a pretrial conference and also allowed for the submission and filing of a motion for summary disposition. The plaintiff has filed such a motion before this court and is asking the court to make a finding that there is no genuine issue of material fact, and that the plaintiff is asking the court to enter a judgment now based upon the case that they've submitted to the court. Ma'am, Ms. LaFleur, you received a copy of that motion, is that correct, ma'am?
Yes.
And I noticed that you didn't file any written response to it. Is that correct also, ma'am?
I spoke to someone already. I just spoke to
Yeah, well, let
someone.
me get the answer to my
Yeah.
question. Certainly, but you didn't file any written response, correct?
The initial I did.
And I think that you know what I'm asking you. It's not a trick question. I just need to get that answer that involves some other stuff. You did file a written response to the motion for summary disposition. Is that correct?
Yes.
All right. Now, you said that you spoke with someone, you discussed this case with someone, when did that happen? Tell me what that was about.
Yeah, they wanted to settle for me to make a payment plan, but I wanted to go up in front of you before I did any of that.
Okay, yeah, I mean, I certainly will do the hearing on the motion. I'm just wondering if there's anything that you have to defend in that regard. When you had a discussion regarding trying to settle this, were the terms of the proposed settlement something that were acceptable to you, or a payment plan, or was there a reduction in the overall amount of the case? Don't tell me any numbers. I mean, usually a settlement involves a discussion about trying to get it resolved. So were you pleased with the terms, or you're not in agreement with trying to settle?
No, I am not in agreement with trying to settle.
All right, very well. So let me hear from Ms. Baker then at this time regarding your motion in this matter. I should indicate that the court allow for the filing of the motion under the order that the court provided, indicating that today the court will hear the motion so long as the motion was filed at least 10 days before this hearing date. It looks like I have a proof of service that indicates that this motion was submitted to the court on October the 26th. We actually received it on the 31st, and that it was mailed out to Ms. LaFleur at or about that time. That would be at least 10 days before the hearing. Madam Counsel, tell me why you believe that this motion should be granted at this time.
Thank you, Your Honor. On February 15th of 2020, the defendant caused a motor vehicle accident with my client's insured by rear-ending her. A copy of the police report was attached to plaintiff's motion. And the date of the accident, the defendant did not have any liability coverage on her insurance, as supported by plaintiff's Exhibit 2, which is a letter from Progressive supporting that statement. As a result of the negligence, there was damages in the amount of $18,047.31 caused to my client's insured. And that amount is supported by plaintiff's Exhibit 3 in the payment logs. Plaintiff brought this cause of action to recover the damages paid to its insured. And the defendant filed an answer stating that she was not at fault with her insurance. Under the Motor Vehicle Code, MCL 257.402, there is a presumption of negligence when someone rear ends another driver. Again, we've also attached documentation to show that there was no liability coverage from the insurance. At a pretrial conference on September 19th, this court entered an order for discovery. On September 21st, discovery requests were served on the defendant, which included a request for admissions, and the defendant has failed to respond to that request. And under the court rules, those statements are deemed admitted. And then again, under MCR 2.116G, the defendant has also not filed a written response to our motion for summary disposition. Based on the foregoing, we believe that there is no genuine issue as to any material fact, and plaintiff is entitled to judgment as a matter of law.
Thank you, Counsel. Specifically with regard to your request to admit as a part of your discovery package in this matter, if you will, for the record, point to a specific item that may bear information on this particular case as it relates to the request for
Sure. Couple of the statements, please admit that you had no bodily injury and property damage liability coverage on any alleged insurance policy that covered your vehicle on or about February 15th of 2020. And please admit that a principal balance of $18,047.31 remains due and owing to plaintiff as a result of the motor vehicle accident in which you were involved on February 15th of 2020. And again, no responses received and those statements are deemed admitted.
All right, thank you, counsel. All right, Ms. LaFleur, anything you wish to say in regard to the motion for summary disposition? You may at this time.
The only thing I would like to say is, I went through my insurance. My insurance Progressive paid for my damages on my car. I know that whoever Monique tried to go through my insurance and they denied that to pay her because they said I wasn't at fault. So now I'm getting personally sued for what?
You're being sued for damages to someone else's vehicle. Your insurer would pay for your damages if you're covered, regardless of whether or not there was fault.
So I guess I have a question of, is it Monique that's suing me or the auto club?
I think you cut me off. I really don't think that you interrupted me while I was talking. So I'm
Oh no, I couldn't hear you. I'm sorry.
All right, so in answer to your question, I wanted to make it clear that if you had coverage on your vehicle, that your insurer will take care of your vehicle, regardless of whether or not you were involved in the accident. The challenge here is whether you had coverage for damage to someone else's vehicle, and in a situation where the report shows that the other vehicle was rear-ended. So you may go ahead and just.
Okay, there was no ticket given to me saying that I was at fault, that I was like a judgment claimed that I was at fault. I guess they just looked at the scene. I didn't have anything that,
Right, you weren't issued any ticket or citation, correct?
Exactly.
All right. Anything else? Anything else anyone wants to say regarding this matter, please?
Nothing further, Your Honor.
No. Nothing for me either.
All right, thank you. Thank you, ma'am. Appreciate it. All right. I've listened to the testimony offered in this matter. I reviewed the motion for summary disposition. Obviously, the court rules require that there be a response to the motion for summary disposition. But I'm taking a look at this just to make sure that we're covering all of the bases before I make a decision in this regard. So that may be something that the court could excuse for purposes of hearing the underlying issue. The challenge here is that even as it relates to the request to admit documents and discovery items, that there was no response to those items. And obviously, when you don't respond to the discovery items, those items are deemed to be admitted herein. I looked at the police report and looked at the items that the defendant did in fact set forth before the court, and her basic claim is that it was not her fault and that she had insurance. Where there is an accident that involves a rear-end collision, where there's a presumption in the statute that the person is driving the vehicle from the rear, there is a presumption, a rebuttable presumption that person is at fault. And without there being anything on this record by way of any documents submitted to this court to rebut that presumption. And moreover, where there is no response to the various items of discovery, and then, of course, no response to the motion for summary disposition, I am constrained to find whether there is a genuine material issue. In fact, it does not seem that there is one. Doesn't seem that there is a dispute that would be recognized in law that would allow this case to move forward. There is no genuine material issue of fact, and the plaintiff is entitled to judgment as a matter of law. There's no need for this case to go any further. All of the issues in this case seem to be resolved, even if I take the case in the light where I look at it from Mr. Flores' standpoint. She had a rear-end accident. It turns out she doesn't have the coverage that is required to cover another party's damages. Her vehicle is covered as her insured would be. In this instance, it would make her liable for the coverage that was afforded to the underlying claim. Accordingly, I don't find that there is a genuine issue of material fact. Plaintiff is entitled to judgment as a matter of law, and I would grant the motion for some disposition on that basis, and I will enter judgment on the terms as framed. The judgment has been submitted to the court. I will sign the same and make sure that the parties receive a copy of the judgment that is being entered in this case. Moreover, Ms. LaFleur indicated something about a payment plan, trying to work something out in that regard. She certainly has the right to file a petition with the court for some type of plan of partial payments that she wants to do that. At this time, the judgment is entered for $18,322.31. That is the order of the court. And again, the parties will receive a copy of that order in the mail in the next few days. I do wish you well. The order for some of this petition is read. Good day to both sides.
Thank you, Your Honor.
Thank you.
The court now calls case number 22-181-636. This is One Detroit Credit Union versus Chantasia Bailey. For the court settle for a pretrial conference. Looks like the court previously had this scheduled in this case. Also looks like there may be a motion. There's a motion for some of this position. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Wilson, on behalf of One Detroit, P number 80307.
Thank you, Mr. Neal. Good morning to you, sir. Do I have Bailey, last name Bailey on the Zoom? Say something if you're there.
Yeah, I'm here.
All right, what is your first?
Judge, I'm sorry, but it's a lot of interference.
Yeah, Mr. Neal, I think your microphone has a lot. Miss Bailey, what's your pronounce your first name for me, ma'am?
It's Shantasia.
Chantasia, gotcha.
Yeah.
Thank you, Miss Bailey.
Mhm.
All right, counsel. So update me, sir. What's going on here?
Your Honor, we had previously appeared and I had spoken with Ms. Bailey in a breakout room regarding a possible settlement. Those conversations were not fruitful, thus causing us to file this motion for summary disposition. We did file the motion with supporting documents and scheduled it for today's date. We have not received any response at this time and are asking to proceed with the motion.
All right, so as I mentioned, Ms. Bailey, previously that I do have that motion that was filed. Looks like it was filed with the court on the 30th of September. And I don't see where you filed any written response to that. Is that correct, ma'am? You didn't file a written response, is that true?
You said a written response?
Yes. To the motion.
No, I did file a response. I went to the court and I submitted paperwork.
Yeah, I see where you filed your answer to the complaint, ma'am. My question is that
Mhm.
you received a motion that's set for hearing on today's date. You didn't file any written response to that motion. Is that true?
No, I don't think so.
All right, not a problem, ma'am. So basically what the plaintiff is saying in this matter, by bringing their motion, they're saying that there is no genuine issue or material fact that this is an account or indebtedness that has been long established, and that there's really not a defense to this claim. So I'm going to give you an opportunity to respond to that. Let me hear from Mr. Neal regarding the gravamen of your motion. Also.
I apologize, Your Honor. I'm kind of losing my voice today, but very briefly, we brought this motion under C9, C10. There's 3 accounts at issue: a deposit account, a loan agreement, and a line of credit agreement, all of which we have supporting documentation for, showing defendant's indebtedness. Per our previous discussions, defendant had reached out to her insurer regarding some payments that she believed to be coming in. We've had no update regarding that. And at this point, we don't believe there's any genuine issue of material fact as to the accounts being established, nor the defaults that we are seeking collections on. Therefore, I do think granting our motion would be appropriate under the circumstances.
Thank you. So, Ms. Bailey, it looks like you had an account or a couple of accounts here with ongoing activities on those accounts, and then it looks like there is a situation where you ended up with some balances existing, some negative balances existing in those that's resulted in this matter coming for today. What do you have to say as to why a judgment should not be entered on these?
What was your last question? I'm sorry, it's a lot of muffling going on.
Not a problem. My question is, what do you, on what basis do you believe that the judgment should not be entered? Plaintiff is saying that basically it is what it is, that there is an indebtedness that occurred here. That indebtedness is in the nature of a total amount of $4,050.70. And they're saying that you owe that and that a judgment should be entered on that. Go ahead, man.
Right. If I wasn't genuine about it, or if I didn't care about my debt, I wouldn't come to court and I wouldn't try to settle. But I had an account with them, and I was always up to date. Payments were on time. But in 2020, I had gotten into a car accident and was out of work for off and on for about 2 years. So that's when my payments start getting behind. And when I had spoken to them about the car accident, they never said anything about my disability insurance, or they never opened a claim for me. They just recently opened a claim for me this summer. And I turned in my paperwork and everything to my disability insurance to cover the payments that I wasn't able to pay. And they just sent me an email Friday that said I have to change my dates on there and send it back to them. Like this Friday that just passed, they sent me email me the paperwork back. So it's like every time I come to court and I'm trying to get everything together, it's always them that's holding me back, really.
All right, so it sounds to me, obviously, that you have you may have credit insurance, and that file is still open, and that you will continue to pursue that. What that means, of course, is that if there is an obligation that you have, they would generally be responsible to pick that up. Although I think we can be judging on that. That is like the only reason they will pick it up is because you owe it. If you don't owe it, then it becomes a gun. So it doesn't sound to me like you're really disputing the debt. What it sounds to me is that you're saying that you should have coverage under credit insurance that was attached to this. And that may very well be true. And I think that you need to go ahead, you need to do whatever they've asked you to do to give additional information regarding.
Sorry, you're kind of going in and out a little bit. I don't know if somebody has their mic on or something.
Well, I don't know what it is. Can you hear me? You hear me okay now?
Yeah, I hear you.
All right. So yeah, it seems like there's a couple of things going on that you may have some coverage that will take care of part of this or all of it. I don't know. It seems like you have some type of credit life insurance or something that may very well help you in this regard. But the issue that's before me today, and when I said genuine issue, that's a term of art. That's a legal term. That's not saying whether or not you're genuine. The court has to assess whether or not there's a genuine issue of material fact in the case. And that doesn't have anything to do with whether the person is truthful or not. That's a legal standard that the court has to evaluate the case on. It doesn't have to do with anybody's truthfulness. It's whether or not, when I look at the entire case, if there is a factual basis or a legal basis for the case to continue to go forward, or whether the plaintiff is entitled to a judgment at this point. It sounds to me that your major defense in this matter is that you likely have a credit type coverage that will cover this. Is that about the size of this?
I'm not sure how much they're supposed to cover, if that's what you're asking.
Yeah, but I mean, that's the basic position that you take, is that they should cover something or all of this, correct?
Right, they're supposed to cover the payments that I missed, that like basically I got behind, and whatever they don't cover, I was gonna pick it up because I'm still trying to catch up on debt and everything, so I don't have to file bankruptcy due to my car accident.
Got it. All right, man. All right, thank you. Anybody else? Any other statements regarding this motion?
No, Your Honor, I think the defendant has laid out that there is a possibility that insurance payments may cover some of the balance. And obviously, if and when that happens, we will credit the account. But I don't think that rises to the level of a genuine issue of material effect as to what we're seeking today before the court.
All right, and I've listened to the motion for summary disposition in this matter. I reviewed and evaluated the underlying facts and issues associated with this case. It does appear that the major issue that is being raised here is that there may be coverage to address the underlying indebtedness. There is no genuine material dispute as to whether or not that indebtedness is indebtedness that is a responsibility of Ms. Bailey. It's her responsibility, and I think that it's everybody's hope that the insurance that she has in place will cover all, or if not all, cover some of this, and nothing about this process prevents her from continuing to pursue the rights that she may have under insurance coverage for payments for failed. But on the underlying issue, there is no genuine issue of material dispute in this case, and the plaintiff accordingly under the law is entitled to judgment by summary disposition. The court will determine that judgment will enter based upon the motion for summary disposition, the motion being granted, and I will enter the judgment upon the terms as set forth before the court. It is so ordered at this time. So, counsel, you can email, because I don't see. Did you submit a judgment, sir?
No, Your Honor, but we will get one over to the court.
All right. So I'm going to ask my clerk to just go on this so we can check the email address.
I can chat.
She's going to chat her email address, the clerk that's working with me. If you get that over to her, I can get that signed up and get it out to both sides. I do wish you well, Ms. Bailey. You can copy the order. You should, of course, continue to go forward with getting the paperwork in, because whatever you owe, if they pay a portion of that or all of it, then that it will reduce what you owe or it will pay what you owe. It sounds like they may have some coverage. I do wish you well. Thank you.
So am I getting another court date to come to for when I get the insurance?
No, you want to come to the other court date, ma'am. You'll get a judgment saying what you owe. When you get the insurance coverage will be required to pay on the judgment. Whatever amount they pay will be amounts that you do not owe. Understand?
No, I'm sorry. My signal is real bad and it's like going in and out.
Okay, so you have a judgment against you for the amounts as indicated, ma'am. And whatever the insurance agrees to pay, or whatever amount they should pay, they will pay that. If they pay that, it reduces what you owe. If they pay the full amount, then it means you owe nothing. If they pay half, then you will owe the balance. Understand?
Okay, and then once they cover something, like, do I contact their attorney, or like who do I talk to if I'm not coming back to court?
You would, more than likely, your insurer will contact them. But once you get a letter indicating that they're going to pay, you certainly should reach out to Mr. Gill's office so that you connect the dots and make sure that you get credit for what they're paying.
Okay, and do I have like a deadline or any type of?
Well, what you have to do is after 21 days, the plaintiff can begin to engage in actions to try and collect on the judgment. If you believe that you're not going to have anything in place by that time, you want to file a petition with the court asking for the right to make partial payments until such time as the insurer make a decision regarding how much they're going to pay. That would prevent you from any type of wage charge by making a partial payment agreement. You understand?
Okay.
All right. I wish you well, man. Good day to you. All right. Thank you, Councilman.
Thank you, Your Honor.
All right.
Happy holidays.
Be in the chat. All right. This is case of Stevens chat. So the attorneys can access. All right. This is case number 22-190352. This is Priscilla Clark versus Mavor Apartments. That's MAVOR. The matter is before the court. Looks like there is a motion filed for summary disposition in lieu of answer. Let me see if I have Ms. Priscilla Clark on this Zoom. Say something if you're here now.
Yes. Hi, good morning, Your Honor. I can hear you.
All right, good morning to you, Ms. Clark. Counsel for Mavor Apartments, your appearance at this time, please.
Yes, hello, Your Honor. Robert Curtis on behalf of Marcon Properties, Bellcrest Apartments.
Your P number, if you will, for the record, sir.
63207.
And ma'am, Ms. Clark, you received a copy of the defendant's motion for summary disposition in this matter. Is that correct, ma'am?
Yes, I did, Your Honor. And I received at a later date. The last hearing that you all had scheduled, they had the wrong address, and I have found that out when I went to 36, and I received new documents.
Not a problem, but you did receive this motion for summary disposition regarding this matter. Is that correct, ma'am?
Yes.
All right, very well. Let me hear from counsel regarding the motion, sir, if you will.
Yeah, thank you, Your Honor. I'll just be brief. You know, this is a motion for summary disposition in lieu of an answer. At the core of our motion is based upon a failure to comply with the statute of limitations. Ms. Clark filed this case styled as a breach of contract. There are a few other allegations in the paragraph that would indicate maybe there's more than breach of contract, but some claims that fall under the landlord-tenant law. In either case, at the statute of limitations, or the longest statute of limitations is 6 years for breach of contract. Just I know it's early, so it's not at the factual stage of the inquiry, but just by way of background, Mr. Edel passed away in May of 2016, and the landlord posted on could not contact. He did not list a next of kin or a contact person in his application, and so they put on Facebook notice of passing, trying to find next of kin. And what happened was, I believe, Mr. Edel's ex-wife or maybe his son reached out initially and showed up, and they provided access to the unit. Subsequently, Miss Clark also reached out and contacted them, and was able to come in and clean out the apartment in June, and she provided a note to the landlord that is attached to the motion that she had cleaned out the apartment and dated it on June 26th of 2016, by which she requested the deposit be fully refunded at that point. The other allegations, I believe, are related to the landlord allowing the other family members into the apartment who apparently or allegedly had taken some things and bank accounts or something. I'm not sure exactly, but I think that's what it's related to. So our motion is basically at the outset, it's a 6-year limitation, a statute of limitation for contract. The case was filed on June 29th of 2022. The notice of cleaning out the apartment, the claim for the deposit was on June 26th of 2016. She missed the statute of limitations by 3 days, and therefore we asked for motion for summary disposition. Oh, the other thing I would add, Your Honor, is that she became it was in, I believe, the following month in July that Ms. Clark was appointed to be out of the probate, the administrator out of probate of the estate.
And so she would not have been, the estate would not have been able to assert the claim until such time as she became the administrator. That's your understanding as well, sir?
Yeah, I mean, the estate wouldn't have been able to serve the claim, but the cause of action arose on the 26th, and so she had a full, more than, a little less than 6 years, but almost 6 years to bring this action.
All right. So let me hear from you. Let me hear from you, Ms. Clark.
Sure.
Raised here. Go ahead, ma'am.
Hi, Your Honor. Several things. There were a lot of untrue things stated. My father last name is pronounced Edley, and when my father passed away, I found out about a month later, and Lisa Snyder had given my father apartment items away in his apartment. That was not his ex-wife. That was his child's mother. And my brother, which is my father's son, he was incarcerated. He was not present at that time. The lady impersonated her own children, which are not my biological siblings. And Lisa Snyder released those items as far as his car. She gave him the keys to his she gave the lady the keys to my father's apartment. They stole a lot of things as well as committing fraud onto his bank accounts. As far as cleaning my father's apartment, I had my father's apartment had been ramshacked. Lisa Snyder, she wrote apologetic. She was very apologetic. She wrote a letter to me. She also promised to release my father's deposit because in my due diligence, it was just trash everywhere. And all I did was throw out the trash, Your Honor. All my father's items had been gone. Again, his valuable items had already been released. Your Honor, with the respect of, I didn't become executive of the state until around about July the 29th of 2016. And also with the respect of the court being closed during COVID-19, there are 12 holidays the court is closed. When Mr. Robert just stated that it's 3 days past the due date, Your Honor, I don't agree with that. With respect of a lot of things that have been at hand. And this is just an awful, saddening situation, Your Honor, from my father passing. And I didn't find out until about 30 days or so afterwards. And then I had to go to the morgue and identify my father's body. I am the only, my father had myself and my brother's incarcerated. I have done my due diligence in effort to contact the department. I mean, not the department, the apartment, Your Honor, all type of stuff. And it's just been awful. It's very awful.
Counsel?
Well, Your Honor, she's identifying some things that that I don't sound like they were the responsibility of the landlord. She's alleging fraud, and the landlord, assuming that it's true that the landlord allowed those persons into the apartment, they did not themselves steal anything. Secondly, it sounds like that's not a breach of contract claim. It's more in the category of a wrongful eviction claim, i.e. wrongfully perhaps putting out items of a tenant without authority is the claim. And the statute of limitations for that claim, Your Honor, is 2 years under statute. So while I'm sympathetic certainly to the situation, I don't see how, one, the landlord is responsible under fraud, and two, or contract, and two, how she's met the statute of limitations in either case.
All right. Okay, anything else from either party?
Yes, Your Honor. Lisa Snyder also wrote in the letter that upon release to my father, she said that they're supposed to have held my father's items for 30 days. They did not do that, Your Honor. Instead, when the lady showed,
You froze up on this Clark. Okay, Ms. Clark, you can hear me. Something happened when you froze up. We can get you back here so we can finish up with this. If you're having difficulties, go ahead and hang up and just call right back in. I'll wait for you. All right, Council, I'm gonna stand down on this matter for just a moment. I'll come right back to it.
Absolutely, Your Honor.
All right, the court now calls case number 21-142-677. This is Sun Secured Financing LLC versus Janet Vanderbilt and David Vanderbilt and Apex Tax Solutions as the garnishee defendant regarding this matter. Your respective appearances in this regard for Sun Secured and also for Apex at this time.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiffs Unsecured Financing.
Thank
Good
you,
morning.
Counsel. Good morning again for Apex Tax Solutions. You may.
Good morning, Your Honor. John O'Shea, P52009 on behalf of Apex Tax Solutions.
All right, thank you. Thank you, Mr. O'Shea. Good morning to you. Let me just check for record if I have either David or Janet Vanderbilt here or someone on their behalf speak up at this time here. All right, looks like there's objection to, well, I'm sure there's an objection to the garnishment or application for judgment on the garnishment. Go ahead and talk to me at this time, Mr. O'Shea.
Thank you, Your Honor. This is, we're here today on my Apex's motion to set aside the default judgment. We appeared before Your Honor on October 5th after my client had filed objections to the garnishment, and Your Honor set the briefing schedule and the hearing today for our motion to set aside the default judgment, which we filed and the plaintiff has responded to. We are here on that motion today, Your Honor. By way of background, a default judgment was entered against my client on May 5th, 2022, relating to defendant Janet Vanderbilt. She was a former employee of my client, Your Honor. She worked for us from March 2020 till September 29th of 2020. She was laid off at that time. The last time we paid her any monies was her final paycheck on October 15, 2020. So as of October 15, 2020, my client had no further contact with Ms. Vandenabel, did not employ her, did not pay her any monies, did not owe her any monies, and still to this day does not. a year later, Your Honor, in September of 2021, a year after Ms. Van Abel left our employ, we received a garnishment from Sun Secured. At that time, my client immediately responded in writing and said she doesn't work here anymore and she hasn't worked here for a year. There was a follow-up with our office manager, Tabitha Saraki, in October of 2021, a conversation with plaintiff's counsel's office. There was a discussion. Ms. Saraki again reiterated that Ms. Van den Abel did not work there for the last year. She gave her last known address, the plaintiff's counsel's office, and said they had no further information in response to the interrogatories that were served. A third time, Your Honor, the plaintiff's counsel's firm contacted Apex. This time, the president, Garrett Lemon, who's here on the call and is prepared to testify if Your Honor sees fit. Mr. Lemon talked to them in December of 2021 and again told them Ms. Van den Abel did not work for us and hasn't worked for us since September of 2020. So my client has always been upfront, Your Honor. They're not avoiding anything. They've told Sun Secured from the beginning they don't owe any money, and it's undisputed that they don't owe her any money. Then a motion to compel was filed. Then there was a hearing, Your Honor, I believe on the 5th of April of 2022, and a default judgment was entered on May 5th of 2022. My client did not receive either the notice of the April 5th or the May 5th hearing and never received a copy of the default judgment. It was only in September of this year, Your Honor, when my client received a notice of forfeiture and lien from their bank saying that they were going to take this money. This was the first time they'd heard about this default judgment. At that time, Mr. Lemon immediately went down to the courthouse, immediately filed objections, immediately retained me. Your Honor set a hearing on the objections on October 5th, at which time I appeared. And we set this briefing schedule for the motion to set aside the default judgment. So we are here today to set aside the default judgment, Your Honor. We believe that good cause exists and there is a meritorious defense. In fact, under the Alkin-Ziegler case, if the meritorious defense would be absolute, if proven, then there is a lesser showing of good cause that is necessary. Here, there is an absolute undeniable defense. We don't owe this woman money. If the default judgment stands, my client will have to pay almost $10,000 of money they do not owe. That is simply an undisputed fact, Your Honor. And good cause exists as well, Your Honor, that my client, again, never hid the ball, never tried to, they told him 3 different times, the woman doesn't work for us, and gave them all information they needed and had, and that's all they could ever offer. And they gave it to him 3 different times. So there is good cause, Your Honor. My client did not know about the motion for default judgment, or they would have appeared at that time. Again, they're not avoiding anything. That when they found out about it, they immediately acted. There is clear, if the judgment stands, Your Honor, there will be clear manifest injustice. My client was not trying to delay any proceedings. My client has not it has not been unreasonable.
All right, Mr. O'Shea, sound like repetition at this point. Thank you.
Okay.
I think I've heard you.
All right.
Well, Counsel, what say you?
Thank you, Your Honor. There's absolutely no dispute that the principal defendant is not employed by the garnishee defendant. What is at dispute here is the default judgment against the garnishee defendant and whether it was proper. To set aside a default judgment, there must be good cause and a meritorious defense. The garnishee defendant has not denied receiving the interrogatories. The interrogatories were properly issued pursuant to MCR 3.101L. In fact, the affidavits filed by the garnishee defendant admit to receiving the interrogatories and basically admitting that they didn't believe they had any relevant information and they were not going to respond to them. A motion request to answer the interrogatories were sent by 3 different letters on November 17th, November 30th, and December 13th, in addition to the telephone communications. When no response was filed to the interrogatories, a motion to compel was properly filed with this court. Again, the garnishee defendant has not denied receiving the motion to compel. They've only denied receiving the notices to appear and the default judgment. But there's been, again, no response to the interrogatories. When a judgment was entered, the certificate of mailing was sent directly to the garnishee defendant at the same address. So the garnishee defendant was well aware that we were pursuing the answer to these interrogatories that we were entitled to under the court rules. And as far as the meritorious defense, the meritorious defense is that the principal defendant is not employed and that they had no information relative to the interrogatories. Well, that's not a meritorious defense as to the foundation as to why this default judgment was entered by the court. The default judgment was entered for a failure to comply with the order to answer the interrogatories. And again, the defendant has not denied that they received the motion to compel. A garnishee defendant cannot choose to not respond to interrogatories because they feel they have no relevant information. And for those reasons, we don't believe a meritorious defense has been filed. If the court does find that a good cause and meritorious defense has been set forth by opposing counsel, we would request attorney fees in the amount of $350 as we previously requested, as the interrogatories still have not been responded to.
All right, so I mean, you would agree, well, I don't know if you agree, but the fact that there is, that it is undisputed that the defendant, the underlying defendant in this matter long gone from the employee appointment of the garnishee defendant, that would seem to be a meritorious defense. I think that obviously you're raising the specter that failure to participate in the process pursuant to the court orders may act as a bar to the exercise of that meritorious defense. That's pretty much what you're arguing about. Is that correct?
Well, we're arguing that the garnishment is a separate lawsuit, and a garnishee defendant cannot just choose what they want to respond to.
Yeah, I kind of short-circuited your long answer for a short way of thinking about it. All right, I got you. All right, counsel, Mr. O'Shea, of course, you've been around here quite a bit, and of course, not responding to stuff is consequential. And I think that's the challenge. I think that you made a pretty strong argument that it's almost like there's sort of manifested injustice that would occur here, particularly where we know that the underlying reality here is that the underlying defendant is not in the employ of the garnishee defendant. Anything else, Mr. O'Shea?
Yes, briefly, Your Honor. Clearly, the meritorious defense is, this is essentially a discovery abuse, a default judgment. The underlying claim is that my client owes $10,000. So there is a merit.
Let me stop you for a moment. The simple question I posed to Ms. Baker is that essentially what she's arguing is that the failure to comply with the rules of discovery, the interrogatory, act as a wall against or a bar against asserting the meritorious defense, if you will. And that really, she's saying that your argument has to be what is the basis for not responding to the process in your laboratory. And I think I get you with regard to what I do get, that the argument with regard to perhaps an injustice that might occur, because we know a fact here, and that is that the defendant did not own or have any resources, did not own or have any resources that might belong to the underlying defendant. So what say you regarding that claim that should be a barrier to be able to assert defense to this underlying claim?
Your Honor, that we did comply. We didn't serve written answers to the interrogatories. That's correct. We did not ignore the system. We did not ignore the interrogatories. We did not ignore plaintiff. We spoken to them. This is undisputed. I think sister councils said that this was true. 3 different times, we talked to them and told them that we didn't. Yes, we didn't technically respond to the interrogatories. That is correct. And we thought that the information, like in Ms. Saraki's affidavit said, when she spoke with plaintiff's counsel's office at the end of October, she said, we don't have any information on her. We have her last known address. Here it is. We don't owe her any money. She hasn't worked for us for a year. They were satisfied or seemed satisfied with that information on that phone call. That's in her affidavit. So this is a situation, Your Honor, where it comes down to a mistake that was made because no formal discovery responses were served, but the information itself, the information that would have been on those formal discovery responses was given to the plaintiff's counsel's office 3 separate times. So
And in fact, that information bears out to be true at this point. That's a critical kind of.
That's correct.
Any other statements, anything else regarding the motion or response to it? Anything else?
I would just say, Your Honor, if Your Honor does set it aside, we do not object to the plaintiff's request for attorney fees in the amount of $350.
Anything else, Ms. Baker?
No, Your Honor.
Yeah, it seems to me that both counsel are on the right track on this. Obviously, the rules as it relates to the enforcement of a garnishment are designed to compel participation in the process, even if the company being garnished does not bear any responsibility. Participation in the process becomes a critical kind of issue because you could end up owing $10,000 where you really don't owe $10,000 of a violation associated with the process. I think both counsels are on the right track. This went awry. There have been critical forthwith omissions or statements by counsels respectively, and that is that we know that the underlying did not work for the garnishee event during the relevant time, that they had no assets belonging. So it seems reasonable and right to the court that the motion to set aside the default in this matter should be granted under these circumstances. Where it would appear that a manifest injustice is likely to occur, and it's a very critical issue of the court trying to get right. I do think that it's absolutely reasonable that the $350 request that has been made is a proper way of resolving the time spent pursuing this. And so I will grant that request. The motion to set aside the garnishee defendant that judgment will be granted at this time, conditioned upon the payment of $350 costs to the plaintiff. So you guys can take care of that right away. Get a word to me so we can close this out.
Your Honor, we'd also request that, I'm sorry. You're cutting out on me. I didn't mean to interrupt you. We'd also request that interrogatories be answered, Your Honor.
Well, I guess I will order that if you just, it seems to me that the issue relative to whether or not the defendant, the underlying defendant worked for Apex Tech Solution, that issue is not a dispute. Why do we yet need to deal with the entrance to the interrogatories?
So under the court rules, under 3.101L, we are allowed to serve interrogatories. The interrogatories are just 8 questions, Your Honor.
I don't mean to cut you off, but I am cutting you off. Let me stop you. Of course, you know the rules and so on and so forth. But you're kind of at the end of the line here. It seems that as it relates to the attorneys, that this is kind of, I mean, if you defendant didn't work there. So what is there some type? I saw it even in the file and affidavit that was submitted. It just seems to me that this is much ado about nothing. It seems that the relevant information is already in the party's field. Go ahead, Counsel.
Sorry, the interrogatories do relate to the garnishment of the principal defendant and her employment. We did attach a copy of those interrogatories. They asked whether, what was there a bank account that her check was being deposited into? Do you know what her last known address is? That information that is relative to her employment with the garnishee defendant.
mean, the relevant information is whether or not they had the assets that were related to this person at the time that this case is relevant. And I understand what you're trying to do is to engage in some discovery so that you might find out more information about the defendant, the underlying defendant in this case. I don't know that that they should have a responsibility under these circumstances to rise to that level. Well, let me ask Mr. O'Shea, any objection to any arbitrators?
I have no objection, Your Honor. I suppose Ms. Baker could serve them tomorrow. I mean, right, so I have no problem with my client saying that they'll respond within 21 days or 28 days.
All right, very well. Let's do that then. Make that a part of the order with the motion setting aside the default is granted. The court awards cost of $350. The court allows the submission of a reasonable and proportional interrogatories to the answer within 21 days. And I'll go ahead and set the 21-day deadline at this time. So I'm going to go ahead and set that let's go ahead and put that on the 14th of December. On or before the 14th of December.
The responses, Your Honor?
Yes, sir.
Okay, thank you.
All right, so get an order to me. I believe that there's information in the chat for the court, for the clerk that you can send it to, so I can get that signed up and sent back to you.
Will opposing counsel be preparing that order then?
I will. Denise, can you give me your email address? So
go ahead and chat to Mr. O'Shea. Mr. O'Shea, our clerk's going to chat to you the email address where you send that to.
Denise, can you give me your email address?
It's on the chat.
Oh, there we go. Great.
And you should also have in the chat the email address for my clerk.
I see them both. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Good day to all. All right, I believe that I have Ms. Clark. Ms. Clark, are you there?
Yes, she said she was on the phone.
All right, yeah, I see you indicating here, but I don't see your, I don't see you on, I don't see you connected. Yeah. You'll have to hang, okay, you gotta hang up the phone now.
Okay, thank you.
All right.
Hi, I'm so sorry about that.
Oh, no problem, Ms. Clark. We decided to stand down while you were trying to get all correct. So, again, the issue that is raised here in the suffix 0352 is an issue of statute of limitations. There's another issue that is associated with this matter. Now you're allowed it. I need to read this part.
I didn't hear you, Your Honor. You said I didn't hear you.
Yeah, it's a lot of interference from her, I believe.
Is she driving?
Yeah.
Oh no, I'm not driving. I'm in the passenger seat.
Yeah, but I got a lot of noise in your background. So anything else you wanted to tell me, Ms. Clark, go ahead, ma'am.
Yes, please. Thank you, Your Honor. Your Honor, yes, they, the apartment complex, Lisa Snyder, she apologized for giving away my father's items. They have breached the contract because they didn't, they had 30 days to at least notify someone. They gave away my father's item less than a amount of time, and they didn't give written notice or anything upon just giving away my father's items. And that's primarily what I wanted to say to you all, just about everything, Your Honor. And there was a lot of untruthful things that Mr. Roberts has stated, Attorney Roberts has stated in regard to my father's items, because my father did pass away. They did not notify the proper next kin or relative, and whether it was in writing or anything, Your Honor, they did nothing. And they just recklessly gave away my father, allowed this mere lady, stranger, to take his car, gave her the keys, allow her full access to the apartment. She made a list of items that she had taken out of the apartment. Lisa Snyder made a full list of the items that were gone. And again, I didn't come as executive of the state until late July. I was almost August.
All right. All right, man. Thank you. You get the last word, I think, Mr. Curtis.
Yeah, thank you, Your Honor. I just want to correct myself earlier. I had misstated the law. So as I see her claims, there's three. There's one breach of contract potentially for the failure to return the security deposit. Two, there's a claim for wrongful eviction for putting out those properties, whether or not they were put on the curb or they allowed someone to come in to get them ahead of time. I don't think it makes a difference in terms of putting them out lawfully. And secondly, I think, or thirdly, I think there might be an allegation in there regarding injury to person or property, as if the office manager, Lisa, who she refers to, did something directly to the property itself. I see those potential causes of actions in the complaint that has been written. That the last one, the statute of limitation for injury to persons or property, is 3 years. The statute of limitations for wrongful eviction is actually only 1 year. I said 2 years earlier. I was wrong. And the breach of action for breach of contract is 6 years. And that is the action that she missed by 3 days, Your Honor. So yeah, it is early. Obviously, we don't have all of our facts correct yet. It's not at that stage yet of proving out those points. We're just here on a purely legal arguments regarding whether or not the statute of limitation has been complied with or not. Your Honor, are you there? I can't hear you.
Yeah, I'm here.
Okay.
Just a moment.
Okay.
All right, I've listened to the complaint that's been brought in this matter, sounding in breach of contract that may be alleging other items. And one of the things is very clear, and one of the initial challenges to any matter is brought before the court is that the court must have the ability to exercise jurisdiction over the subject matter. And one of the things that allows for the court to exercise jurisdiction over the subject matter is that the matter is brought within the time permitted by law. And where there's a claim of breach of contract, then the breach of contract action has to be brought within 6 years of the breach. And the claim arises when there is the allegation that a breach has occurred. And in this matter, clearly, the complaint in this matter is brought more than 6 years after the period for which the breach is claimed within this matter. Notwithstanding the fact that it wasn't until July of 2016 that that an estate was established. Still in June of 2016 is where the claim arose in this matter. Moreover, there are claims here that that someone may have defrauded the decedent in this matter. Indeed, that the apartment complex may have been involved in that kind of fraud. Certainly, that would be a shorter statute of limitations. Anything that has landlord tenant type issues are not even before. There's the other challenge that is raised. The other challenge that is raised as the court assesses this, and that is the real party of interest. To the extent that there is a suit that is being brought to protect the interests of the decedent in this matter and his heirs, that suit seems to me would need to be brought in the name of the state. That is the real party. The estate is the real party of interest. And here it seems that Ms. Priscilla Clark is suing on behalf of the decedent, Mr. Philip Italy, and the law doesn't allow her to bring an action in her own in regard to a claim that Mr. Italy might have had. That would be a claim that would arise under an estate that's been open. So this does not seem to be a real party of interest type of case. But even if we have a real party of interest, one way or the other, the case is time barred. At least the issue that is brought before this court is time barred. It's outside the statute of limitations, not brought within the 6 years that it could have been brought. And for that reason, the case in this matter dismissed on motion for summary disposition, where the court finds that the bringing of this action is too late because it does not comply with the requirements of the statute in relationship to a breach of contract cause of action. The case is dismissed according to motion for summary disposition. That is my order, and I will sign a written order consistent therewith. I don't see that there was an order attached to the motion. So, Council, if you will submit an order, I will sign the order consistent with the court's determination. All right, I will also submit the date to you. And Council, you can send that to Carmen.Banks. First name Carmen, C-A-R-M-E-N .Banks is the last name, B-A-N-K-S at 36 District Court.org.
Thank you, Your Honor. I appreciate your time.
All right, good day. Good day to both.
Thank you.
All right, this is case number. All right, this is a recall on 2218-3381. This is Albion Funding versus Iola Hall. That is before the court. I did receive an answer to this complaint. I did set it up for a pretrial conference on today's date. The court previously established a schedule for allow for discovery through today's date. Your appearance for the plaintiff in this matter, please.
Judge, may I please court? I'm attorney Richard Roos, and I'm the attorney of record for the plaintiff, and I'm the attorney of record in this pretrial.
Thank you, Mr. Roos, and good morning to you. I'm looking once again for Iola Hall. I called from Ms. Hall earlier. Ms. Hall, if you are on this Zoom, please say something at this time. All right, counsel, what's going on here? Updating you, sir.
Judge, in this case, this is an assigned debt from a credit card named Credit One. Defendant is not here today. I would ask that the court issue a failure to appear default so that defendant can be given notice of the pendency of this matter. And if she doesn't respond, I'll then follow up with a default judgment.
All right, given that the defendant has not responded to the court's call in a review of the file, I'm noticing that the address defendant provided in her answer on Vaughn Street in the city of Detroit is the location where the court's notice was sent. Again, that address was provided by Ms. Hall. She is not appeared for this hearing, and accordingly, the court will enter, will find that the defendant has failed to appear, will enter default accordingly. The court will allow for the entry of judgment on that default in due course. Right, so.
Thank you, Judge.
The court calls case number 22-192-376. This is Antonio Strong versus Regency Heights, Detroit. The matter is before the court, set on for a motion for summary disposition. Also have. All right, strike that. Your appearance, well, let me ask, do I have Antonio Strong on the Zoom? If you're here, say something at this time, please. Antonio Strong, looks like I see you there. Mr. Strong, if you could unmute yourself, *6, and say something at this time, please. Mr. Strong. One moment.
I don't think he heard you, Judge. To use *6.
Mr. Strong, if you're there, use *6 and you can communicate with me. I don't see an indicator. Check.
There it is.
Good morning, Mr. Strong.
Hello.
Good
How
morning
you
to
doing?
Good. You're Antonio Strong, are you?
Yes, yes. My name is Antonio Strong.
All right. Good morning to you, Mr. Strong, and thank you for your patience in this regard. This matter is before me today because you filed a case, and then there is a motion that's been filed by the defendant, and they're asking the court to reach a judgment regarding this case and to dismiss the case. Did you receive a copy of that motion, sir?
No.
All right, well, let me check up on that and see what's going on here. All right, your appearance for Regency Heights, Detroit, please.
Nicole Robertson, Piero 612 for Defendant Regency, Your Honor.
All right, and good morning to you, Counselor, and thank you for your patience in this regard as well. Yeah, I set this up for motion hearing on today's date. Mr. Strong is saying that he hasn't received a copy of the motion. I see that you have stamped on your motion, Counsel, that the matter was sent by mail on the 12th of October to Mr. Strong at the Hudson Street address. Mr. Strong, you still live on the Hudson Street address, sir?
Yes, I was. I know moved though. I'm not in Detroit now.
So where do you live in? You live in Detroit? Where were you living? So where's Hudson Street? Hudson Street, that's in Detroit, is it?
Well, no, that's in Warren.
That's in Warren. Not reported. Did you say something?
Nope, that's background at his place. Nope.
All right, thank you. All right, so, Madam Counsel, so Mr. Hudson. Madam Counsel, I do see on the motion that it has Hudson Street in Detroit, and it has a zip code 48089. That would, that certainly would mean that something is off. The complaint has the Hudson Street address in Warren at that zip code. You see, are you
Can I say
seeing what I'm
something?
saying? 1 second, Mr. Strong. Madam Counsel, are you seeing what I'm seeing on your motion? Somehow Detroit got superimposed for the city of Warren, and the certificate of mailing will likely have sent it to send that to Detroit, and that would be the proper address. You see what I'm talking about?
Yes, Your Honor.
So, Mr. Strong, I'm gonna tell you a little bit about this motion, or she's gonna tell you a little bit about the motion in just a moment. You said you wanted to say something. What is it, Mr. Strong?
Well, it's no courts or whatever and stuff. I'm going to court and everything and stuff, all day long, and I was putting on my brother address. But I moved, I got a place now or whatever, and I moved to my address in Detroit.
Okay. Why don't you go ahead and give me that address, sir, so I can make sure we mail things to you. What's that address?
It's 11177 East 7 Mile.
Okay. That's 48204.
48234. 48234.
All right, got you. So 11177 East 7 Mile Road, 48234, correct?
Yes.
Okay. All right. So you filed this. Let me get into this. You filed this complaint. It says they have a guardian. I have papers to prove. I have half off. I got greetings for other place, and they haven't done anything. So what is this? Are you suing regarding who is guardian? Who are you talking about?
Yeah, I got a half a guardian. I ain't got no guardian. I got a half a guardian.
Oh, okay. So is that a person that the probate court assigned to you?
Yes.
Okay.
Civil court.
You're still in court on the guardianship. So what are you suing? What are you suing Regency for?
Well, the social worker, the administrator, and everything and stuff. They telling me lies to me. Now, I got a gunshot wound in my brain. The right side of my body is paralyzed, and I got a stump on the left side. And the results or whatever, I can't know how they talk that well and stuff. I'm talking, to y'all now or whatever. But when there's no real stuff, going on or whatever stuff, I don't know what I can't speak on my behalf or whatever stuff. To get the stuff, what I'm saying and stuff. But I got pictures. I got documents and everything and stuff. And my social worker and my administrator and 3 or 4 things in this building or whatever, they be telling lies to me. And I got a LLC. I was doing a whole lot of stuff for me on my computer, but they talk to me. They tell me what's going on or whatever and stuff. So I can't do it no more or whatever and stuff now or whatever. Till I get all that stuff situated or whatever, so I can do it again and stuff for my disabled or whatever. Now they telling me no, oh yeah, you can't do this or you can't do that and blah they speak, but they telling me lies because I got paperwork that's saying no different.
Okay, so you've been to probate court to explain that to the probate judge, that you can do some things that they're saying that you can't do. You told the probate court judge that?
Yes.
Okay, so it sounds like to me that what you're trying to do, so Regency Heights is the custodian or the guardian that the agency that is responsible for overseeing your care.
Yes.
Okay, and you want them to be removed. You don't want them to be a guardian, correct?
That's what I'm trying to say. I always know I see that I can terminate my guardianship. I put in the letter or whatever because they telling me they I can't go nowhere or whatever and stuff. But I got paperwork saying that I'm a half a guardian. So I'm doing what they saying to do or whatever, and then I can leave wherever I can leave or whatever and stuff. I'm a half a guardian. I ain't got no guardian. And I put in the paperwork saying terminate my guardianship.
All right.
But they hold on or whatever and stuff. So I gotta call my mother to do it for me or whatever and stuff because they holding back or whatever and stuff. They don't want to they don't want to basically telling me nothing or whatever about me. I'm Antonio Strong. I got a guardian over me or whatever, and I can't get all the information for me.
All right, got it, sir. So it sounds like you're in the wrong course, really. Let me hear from Ms. Robertson in regard to this matter. I think I already got your appearance at our council.
Yes, Your Honor, thank you. Yes, it does sound like a wrong court. This is a motion for summary disposition based on failure to state a claim based on the complaint that Mr. Strong had sent to us. On the complaint he sent to us, he didn't plead any allegations. He just said they told me lies and the doctor and the social worker are false. Doesn't say what lies were told, what was asked, or any other details. He's also alleged pain and suffering, but hasn't alleged an injury. So based on the MCR 2.1168, we're asking for a summary disposition due to failure to state a claim for this case. So we would ask the court.
Oh, I'm sorry.
Oh, I'm sorry, Your Honor. Go ahead.
Yeah, Mr. Strong, you're in the wrong court. I mean, all the issues that you're raising, you have to raise those in probate court. You have to file a proper petition there and let a probate judge decide those issues. You're alleging that there's something that's gone wrong with the agency that is overseeing your affairs. While I know that you did not likely receive a copy of this motion or summary disposition, without even addressing the motion, just looking at the complaint and assessing the complaint that you raised, you got to raise these issues in the probate court. Wayne County probate court, if you were in Detroit, if you were in Warren, it would be in the Coleman probate court. So wherever your case is where you have to raise the issues that you have sought to bring in this court. I don't see a cause of action in this court. You may have something to raise in the probate court. You don't have anything to raise here, and I don't see anything on which you can recover monetary damages as your complaint is styled. It seems that you have grievances against the social worker and other persons involved in your care, and those grievances may be accurate. But you haven't alleged anything that upon which the court could grant you relief, at least this court. It sounds like the issues that you need to raise are issues that you need to raise in the probate court. But either way, when I look at this complaint, I don't see a cause of action in this court. I don't see something that the court, that this court, even if I saw everything the way that you say it, I don't see anything in this complaint that would give me the right or the authority to issue any kind of order against you, or sorry, against Regency. So what that means, Mr. Strong, is that you're likely in the wrong court with these issues. And I'm going to dismiss the case because you're in the wrong court, sir.
Okay, well, I know I tried to get, my, purple bono, a lawyer or whatever stuff. I was tried or whatever stuff about 3 months. And I can't get this or whatever and stuff. But I need somebody who can defend me or whatever to tell me what's really going on. I got like a whole lot of paperwork or whatever that's proven they just telling lies to me. First they saying they was helping me out or whatever when I first got out. I mean when I first walked in or whatever. But then after they called my social worker, then they telling lies to me. And I asked them about 4 or 5 times or whatever and stuff, So I got paperwork or whatever that prove that they lying to me or whatever, and I got paperwork that proves that.
All right. So
but I need a pro bono or a lawyer or whatever for defend myself, and I ain't got no money or whatever, but they can give me a pro bono the first time or whatever.
Okay, you filed this case with 36 District Court. If you believe that you have some grievance that you want to bring before a court, you have to file it in the probate court. And whatever paperwork you got in probate court, it has a case number on there, and you want to raise the issues. Use that case number to, just like you filed something in 36 District Court, use that case number to file it in that court. I believe that would have been the Macomb County probate court. So because you're living in Macomb County.
Yeah, that's what that was I was trying to do or whatever and stuff. They told me or whatever, that they got on Zoom or whatever. They can't do it right now or whatever. So I keep trying. When I come, I'm just happy. But I'm still keep trying. I'm trying with my wheelchair to get this done or whatever and stuff. And they was telling me or whatever. They it's Zoom on there or whatever. Now you got to hold on. You got to wait or whatever. So I trying to do that 3 times.
Yes, sir.
Whatever and stuff, and I can't do it. They basically whatever. They destroyed me. They a year and a half. They got my checks or whatever stuff. So I'm trying to see what's really going on and stuff. So I seen they I gotta go a half ago. I ain't got no whole guardian. Why y'all holding me? Why y'all I can't leave?
Yeah, you have to take
stuff
all
like that. I said I fax a whole lot of stuff to Regency Heights or whatever stuff. They said they're going to do it or whatever stuff, but in actuality they ain't never did it.
Okay,
never.
You're gonna have to take all of that up with probate court, sir. That's where you have to take that up at, in the probate court. This is the district court. You got to go to the probate court and use the case number that you have.
So what is a district court? What's that?
That's the court that you're in right now. But the type of claims that you are raising here today, that you're not happy with the guardianship, that they're not treating you right, they're not treating you fairly, that you need that in probate court, because the probate court is the court that appointed someone to oversee your affairs. So you have to raise those issues in that court. They do not come properly before this court, right? So make sure you follow up there. All right. I do wish you well.
Could I say something?
Yeah,
Can I say something?
Yes, sir.
I ain't got I ain't got no guardian no more.
All right.
I'm my own man now. I ain't got no guardian no more, whatever, I terminate my guardianship and everything.
Did the court terminate it for you? Did the court give you an order terminating it?
No, they say, that my mother gonna be my assaulter and handle my affairs right now. I'm
Okay,
going
well,
to court, next month.
That's when you want to raise all these issues you've been talking about. When you go to court next month, that's when you raise those issues, sir. That's when you raise those issues, all right? I wish you well. Good day to you, Mr. Strong. Thank you, Madam Counsel. I'll submit an order of dismissal based upon the court's sua sponte determination that the complaint does not on its face establish a cause of action. If you'll submit that, I'll sign that order, please.
Thank you, Your Honor.
So
All right, good day to you, Mr. Strong. I wish you well, sir.
that's where we are messed up.
Yeah.